All right, and now it's time for the last panel of the day. Before we begin, I do want to just remind everybody that our next conference here will be March 22nd on the subject of religion and the administrative state, followed by a conference in Washington, D.C. at the Decatur House near the White House on political polarization and the administrative state. So we hope you will join us for those. Our last panel today on Chevron, non-delegation, and the major questions doctrine is moderated by our colleague, the Center's Deputy Director, Andrew Closter. He recently joined the Gray Center as our Deputy Director, where he works on all aspects of the Center's activities. Before joining the Gray Center, he served in the U.S. Department of Transportation as legal advisor to the General Counsel, helping to oversee the department's regulatory reform efforts and legal operations. Previously, Andrew was a legal fellow at the Heritage Foundation, and he clerked for Judge Daniel Mannion of the U.S. Court of Appeals for the Seventh Circuit. Thanks, Andrew.
All right, thank you, Adam. And thank all of you for sticking with us through the end. I think we're anchoring down the day with a very good paper by Adam Gustafson, so I'll leave it to Adam to discuss his paper. Adam is a partner at Boyd & Gray & Associates, PLLC, where he has represented states, federal judges, environmental groups, and many other interested parties on issues involving separation of powers, the First Amendment, automotive regulations, and others. He received his JD from the Yale Law School, where he was an editor on the Yale Law Journal, and where he also served as a vice president of the Yale Law School Federalist Society. And he is also a graduate from the University of Virginia. So without further ado, Adam, please tell us about your paper.
Thank you, Andrew. And thank you, Adam, for having me here today. I feel a little inadequate to be talking about the major questions doctrine here at the C. Boyd & Gray Center for the Study of the Administrative State. Can you hear me? How's that? Because, help me out.
One that says ON.
I'll try to just talk really loud. All right.
You got it.
Well, back in the old days when Adam White and I worked together, he was always the brains of the operation in our major questions cases, including, by way of disclaimer, some of the ones that I'll be talking about today, including the net neutrality case in the DC Circuit and the UR, the Utility Air Regulatory Group case involving greenhouse gas regulation of stationary sources, and King v. Burwell, involving the Affordable Care Act and exchanges established by a state, whatever that means. But it's an honor to be here.
I believe it's a tax.
That's what I hear. It's an honor to be here to talk about this. So as for any non-administrative lawyers in the room, the major questions doctrine it tells us that Congress must speak clearly if it wishes to assign an agency decisions of vast economic and political significance. That comes from FDA v. Brown and Williamson Tobacco Company. The doctrine began as an exception to the Chevron doctrine, to Chevron deference, judicial deference to agency interpretations of statutes. But my thesis in this paper is that the major questions doctrine as a non-delegation canon of construction can operate independently of Chevron deference. So I'll start by talking about where this doctrine comes from. In the case I mentioned involving Brown and Williamson Tobacco Company, the FDA was regulating tobacco and cigarettes as drugs and drug delivery devices. And the Supreme Court was asked whether that was right, whether the agency had authority, jurisdiction to regulate that. And the court proceeded according to Chevron, asking first whether Congress has directly spoken. And of course, if Congress has directly spoken, then the court has to decide whether the agency's interpretation of the statute is reasonable. And in this case, although the statute looks ambiguous on its face, the court said that ultimately the statute wasn't truly ambiguous because for a couple of reasons. First, the structure of the statute made it impossible, the court said, for Congress to have intended that the FDA would regulate tobacco. There are other, basically, the court said, this statute's only set up for drugs that can be safe. And the FDA has already conceded tobacco can never be safe. Hence, it doesn't fit within the statutory scheme. But more important to the discussion today, the court said this was an extraordinary case, citing a law review article that then Judge Breyer had written. Breyer had said, a court may also ask whether the legal question is an important one. Congress is more likely to have focused upon and answered major questions while leaving interstitial matters to answer themselves in the course of the statute's daily administration. And the court said, this is such an extraordinary case. This is a major question because tobacco has a unique place in our political life, and because Congress has taken steps after the passage of the Food, Drug, and Cosmetic Act to regulate tobacco in ways that are inconsistent with regulation under the FDCA. So the court concluded that Congress could not have intended to delegate a decision of such economic and political significance to an agency in so cryptic a fashion. That's a quote from Brown and Williamson, and that line is the germ of the major questions doctrine as we now know it. It comes up again, and in my paper I characterize the Brown and Williamson statement of the major questions doctrine as the standard version of the doctrine. We see the standard version again in the Utility Air Regulatory Group case. Ambassador Gray alluded to this morning. This is the one where the statute required regulation for any pollutant if a source emitted more than 100 or 250 tons in a year. And so based on Massachusetts versus EPA, EPA said, well, we already know because the Supreme Court's told us that greenhouse gas is a pollutant, therefore we can regulate greenhouse gas under this provision. And the problem was that if you were to regulate greenhouse gas using that threshold, pretty much everybody would be covered by it because we all emit a lot of greenhouse gas, a lot of carbon dioxide. So the Supreme Court tailored the rule. They said, well, we won't use the 100-ton threshold. Instead, we'll use 100,000 tons. And so the court was evaluating whether EPA had authority to do this. They said no. Although the court agreed that the statute was ambiguous, the court denied deference because EPA's interpretation was unreasonable. It sounds like a step 2 analysis, doesn't it? But the court said it's unreasonable because it would bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. So if you look at FDA, Brown and Williamson, and the UARG case closely, you might be tempted to think that they're doing this major questions analysis at step 1 in the case of Brown and Williamson, step 2 perhaps in the case of UARG. But what commentators and legal scholars have generally agreed on is that actually what's happening here is what's called a step 0 argument, that the courts have said when there's a major question, we're not going to do our normal analysis of whether the statute's ambiguous. We won't do our normal analysis of reasonableness because that Chevron framework doesn't work in the case of major questions. So I said that was the standard version of the doctrine. It forces the question back to Congress. When there's a major question, the court says, in effect, the agency can't decide, and importantly, the courts aren't going to decide. If Congress wants this to be done by an agency, it needs to say so clearly. So what's the non-standard version of the major questions doctrine? In King v. Burwell, the case about the Affordable Care Act and exchange established by a state, the question was whether the IRS could allow tax credits for insurance plans that were purchased not on exchanges established by a state, as the statute said, but by exchanges established by the federal government. And so what Chief Justice Roberts did, writing for the majority, was very interesting. He used the language of the Major Questions Doctrine, but instead of kicking the question to Congress, instead of saying, this is a major question, it would affect a big chunk of the economy, and therefore Congress has to speak clearly if it wants to do this. Instead, the court said, the agency may not decide this because it is a major question, but we, the Supreme Court, will decide it, and we decide that, yes, in fact, these tax credits must be given for exchanges purchased on, for plans purchased on federal exchanges. So I call this the non-standard version of the Major Questions Doctrine. I think it's an aberration from the standard version, from the Brown and Williamson version. And I think it's potentially dangerous. I think it is dangerous because I think it puts courts in the position of deciding the questions that are the most contentious, the most politically important, and therefore the ones that are most appropriate for legislative action and least appropriate for judicial action. So it also, I think, basically lets Congress off the hook because it says Congress can keep passing broadly worded statutes, and when something needs to get done, the courts will be there to be the backstop and make sure if it's too big to fail, it doesn't fail. And of course, it encourages agencies to keep being creative with statutory language, to do big, important things, hoping that the courts will back them up. I think that's the non-standard version of the doctrine's dangerous. It puts all the incentives in the wrong places. But I think that's not true of the standard version of the doctrine, which requires Congress to legislate and which requires courts to step back on major questions. So another case I'd like to talk about, because its author's now on the Supreme Court, is the net neutrality case. In that case, then Judge Kavanaugh dissented from the majority, from the en banc majority. He said that the FCC's regulation of the internet was a major question, and that therefore the FCC should wait for Congress to speak clearly rather than reaching back into the Communications Act and finding there a brand new power to regulate. I'm interested in Kavanaugh's dissent because I think he provides, he's resisting one of the criticisms of the Major Questions Doctrine, which is that it gives too much power to judges. What he does is try to, I think, provide some more objective criteria. He talks about it as the Major Rules Doctrine, which to me suggests Executive Order 12866, the idea that we can determine what are the significant regulatory actions about which a higher level of scrutiny is required, and that those can be known. So he talks about the amount of money involved, and the number of people regulated, the length of time that the statute was in existence, and the factor I like least, the degree of congressional and public attention to the issue. I like that least because I think that's the most susceptible of differences of opinion. Of course, all these factors don't eliminate the line drawing problems, but I think that they do provide some potential metrics for evaluating majorness. So I'll close by saying I think that the Major Questions Doctrine as a non-delegation canon can work and is working outside of the Chevron context. We normally think of this as an exception to Chevron, but really it's a non-delegation canon. And I think there's good reason to think that courts that are concerned about Chevron, because it is a symptom of over-delegation by Congress, might want to continue to use major questions doctrine, even in cases that don't necessarily involve Chevron. That could happen because Chevron is whittled away or even overruled, or it could happen because agencies decline to request Chevron deference. They either waive their potential claim to Chevron deference, or the agency interpretation does not appear in a document that would be entitled to Chevron deference. So I'll close with one example of this scenario. So just this month in the Fifth Circuit, Judge Ho on the Fifth Circuit wrote a concurrence in his own opinion. The case involved the question whether the EEOC was right to extend Title VII protection against discrimination on the basis of sex to include discrimination against transgendered people. The EEOC said yes, and the Fifth Circuit decided no based on some long-standing precedent. Judge Ho concurred in his own opinion to say, even if that precedent weren't there, this is a major question that's not appropriate for decision by an agency. If Congress wants to regulate discrimination on the basis of transgender status, it can do that, but it should speak clearly. And it was an interesting opinion because it did not cite Chevron at all. There was no claim to Chevron deference at all. But Judge Ho went back to the canonical sources of the major questions doctrine, Brown and Williamson, and UARG, Utility Air Regulatory Group, and said this is a significant policy question that, quote, must be decided by the people through their elected representatives in Congress using clearly understood text, not by judges using oblique, cryptic, or subtle statutory parsing. I think this is an example of a court using the major questions doctrine outside of Chevron's shadow to limit not just the power of agencies to expand their own jurisdiction, but also to limit the power of judges to decide whether agencies should expand their power.
Thank you, Adam. And I would be remiss if I didn't mention that Adam's paper and all of the papers from today's conference are available on our website. So please go there if you'd like to take a look at the Fifth Circuit case and the other cases and materials that are cited. So our first commentator is Professor Rena Steinzer, who is the Edward M. Robertson Professor of Law at the University of Maryland, Carey School of Law. She teaches administrative law, food safety law, contract law, and advanced courses on the regulatory system. So we're very pleased to have her here. She is a founder, immediate past president, and member scholar of the Center for Progressive Reform, CPR, and she has testified before Congress on several occasions, most recently regarding the impact of health, safety, and environmental regulations on the economy. She received her BA in history from the University of Wisconsin-Madison in 1971 and her JD from the Columbia Law School. So thank you very much for being here, Professor, and please share your thoughts.
Well, first let me identify where I agree, because most of the rest of what I have to say will be in vehement disagreement with everything that's been said today. And I say that with a smile. Adam knew when he invited me. What I agree with is that the dysfunction of Congress is the biggest problem that faces the nation apart from climate change. And that's a pretty big statement. We didn't mention that today, but that's a big problem. But rather than insisting that Congress do its job, come to work 5 days a week, actually pass legislation, amend statutes that are outdated, however it see fit, instead what we're doing is what we've been doing for a number of years, which is to launch stealth attacks on statutes that, for whatever reason, ideological reason, we don't like. And I think that's pretty dangerous. I especially think it's dangerous when judges do it, but more on that in a minute. I was once testifying before the House Energy and Commerce, a subcommittee of House Energy and Commerce, and it was one of those hearings where there are 8 witnesses that are furious about the Clean Air Act and me. And I finally said, as Congressman was telling me that I was eating up his time and that he would like to have a yes or no answer, please, I said, sir, if you are so frustrated with the Clean Air Act, why don't you amend it? And his answer to me, which was, it was a good thing he wasn't sworn in, was that he loved the Clean Air Act, and he absolutely would not consider amending it in a way that would have anything to do with dirty air. And that's why we've been forced down all these cul-de-sacs and blind alleys, and the major question doctrine is one of them. I would point out that in Brown and Williamson, which was a 5-4 decision, Justice Breyer was in the minority. The idea of quoting his own law review article in an effort to embarrass him by the majority was undoubtedly, has become a strategy that a lot of judges use. I don't think it's suitable for the Supreme Court. But Justice Breyer was perfectly comfortable with the idea that the FDA could do more than just ban cigarettes. It had the discretion to approach the regulation in a reasonable and rational way. The major questions doctrine would basically say, give judges the power, and I do think that Adam's effort to describe it as a step 0 doctrine is very helpful, because that is, in fact, what it would do. It would take the decision out of Chevron, put it in front of the judge, and ask the judge if he thinks that whatever the policy at stake is too important to be left to the president supervising the executive branch and carrying out the law. The president has certain democratic credentials himself. And instead, a judge would say, for reasons that have to do with a bunch of factors, how many times I hear about this in the newspaper, as Adam acknowledged, I don't think that this decision should stand. That's what the major questions doctrine basically would do. And it would tear down the entire law, not just a part of it. It is the antithesis of avoidance doctrines that have been in the jurisprudence for a lot longer than this one has. As Justice Scalia once said in a different context in the Zuni case, that is a judge-empowering decision if I ever saw one. He was lamenting the majority's decision to embrace what the agency said about the statute, even though he thought the statute was very detailed and directed a decision that was different than what the agency had come up with. Now, I would point out, and this is something that we haven't done all day, there's been a sort of an absence of discussion of who is actually interested in these questions. And I would like to bring out the concerns of regulated industries, which seem to me to be the folks who would have the wherewithal to litigate these cases and the interest in doing it. They would be very unlikely to bring up this kind of concern for one very clear reason. Congress doesn't write vacuous, empty, open huge gap-filling statutes anymore. As the speaker at lunch, who I thoroughly enjoyed, has said, Congress writes very specific statutes, especially in areas like the environment, which are the kinds of statutes that the regulated industries most love to hate, and which are a feature of what is clearly turned into a very obvious and heated war on regulation. So I think you would have difficulty finding too many plaintiffs in these cases. The doctrine of major questions and the non-delegation doctrine, a doctrine that has not been invoked by a court in 8 decades, is going to be something that Justice Kavanaugh likes very much and has argued for, but he will have a very hard time, I predict, getting the right kind of case where he could win a majority on the Supreme Court. So, in conclusion, I guess I would say that the entire argument of a major questions doctrine assumes that Congress can be more precise, that it doesn't do gap filling deliberately, that it can write down every imagined concern, that it would be okay to churn the system by constantly leaving the agencies and Congress unclear about what level of precision would prompt a major questions overturning. And this would have one effect, and one effect only. It actually is a double-edged sword. It would put the entire regulatory system in an unstable place. It would mean that business did not have any certainty about what the regulatory state was going to ask of it. It would provoke agencies to write interminable statements of basis and purpose and interminable notices of proposed rulemaking. And this would be a problem when you had a president like, I want you to stay calm, Elizabeth Warren, but also Donald Trump, because Donald Trump, in unwinding all the regulations that people don't like, is encountering procedural hurdles. If the hurdles were even higher, it would cause problems. And there are reasons for those procedures, and I don't think this sideway effort to sort of tilt the playing board is something that both sides, either side, should want.
I guess before we go to our second commentator, I'd like to give maybe, Adam, if you'd like to respond to any of the points that were made. I think particularly the one on the political valence of the doctrine as you see it. Is it necessarily a one unidirectional kind of a thing?
Well, on that point, it's unidirectional in the sense that, at least the standard version of the doctrine is, am I on? I can't tell, I'm sorry.
Yeah, you are.
Okay.
You're just so soft-spoken, you know.
Try to yell. Standard version of the doctrine is unidirectional in one sense, and that is that it always pushes the question back to Congress. And that is why it's a pro-democracy canon of construction, because it requires clear statements from the legislative body. That kind of unidirectionality, I think, is not a problem. I think that's a feature and not a bug of the doctrine. But I think it could be applied and should be applied against Republican administrations and Democratic administrations alike. So in that sense, I don't think it's a inherently biased canon. I agree about one of your criticisms of the doctrine, and that is the statements in some cases that look to, you talked about how many times I've read about this in the paper. Some of these cases talk about how many times bills have been introduced that touch on the area. I think that's very difficult to measure, and I share your anxiety about that. I think that should not be one of the criteria for major questions doctrine because, as you point out, it injects this uncertainty and a possibility for differences of interpretation on the part of judges. But I'm not overwhelmed by that criticism because I think it's actually not that important a factor, even in the cases where it's mentioned. Judge Kavanaugh, who authored the dissent in the net neutrality case that I mentioned, it's not the first time he's applied the major questions doctrine. He did so in a case called Loving the United States about tax preparers, and there was nothing in that case about the political valence of the issue. So I think the court's focus should be on the economic and political significance of the issue, not on how many times Congress has tried to pass legislation on it or how often it appears in the daily news. The last one of your last points, Rena, I'm interested in the idea that I think your assumption is Congress can't be more precise than it already is. And that's, maybe I've been working for Boyd and Gray for too long, but I haven't lost the optimism that it can be more specific when it wants to be. I think, and I would dispute the idea that Congress doesn't operate under an assumption that it will deal with major questions itself. There was a study by Abby Gluck and Lisa Bressman that looked at how congressional staffers actually do legislative drafting. And about some canons of construction, they were oblivious. But the major questions doctrine is one that, interestingly, they were aware of, at least in principle, and that they operated on. Their paper includes quotations from staffers who say, major questions, we would never leave those to the agencies. We do those in-house. They said more than 60% of respondents said that something like the major questions doctrine was operating in the background of their legislative drafting. So maybe I'll just leave it there for now.
All right. Well, our second commentator is Ilya Shapiro. He's the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. Ilya is the editor-in-chief of the Cato Supreme Court Review.
No longer.
No longer.
No longer.
Oh,
But you have other hats.
11 volumes was enough. I've passed it on.
you won the pie eating contest.
Yeah.
He's the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution from 2014. He's a quite regular lecturer for the Federalist Society, was a Lincoln Fellow at the Claremont Institute, and has been adjunct professor at the George Washington University Law School. He clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit, and holds degrees from Princeton, the London School of Economics, and the University of Chicago. So, Ilya?
Yeah, thanks very much for having me here. I'm just a simple constitutional lawyer, so being invited to talk about something so advanced as administrative law is quite the honor. Admin law was actually my worst grade in law school. I blame Adrian Vermeule wholly for that. As a simple constitutional lawyer, the arguments over Chevron and now major questions doctrine strike me as odd because there's not a clear answer. Because it's not like, in the beginning, the framers of whatever amendment or the original structures or what have you put the administrative state in place this way. And, we've deviated from that, or courts have done this or that. When you're dealing with at best, a second-order structure, where there's no first principles, as it were. It's hard to think about what the right answers might be. Well, then you might say, well, the right answer must be what gets you the best policy. Well, that has an ideological valence, I suppose. And then that sets up this odd bedfellow debate because, of course, Chevron itself, which now is identified with the right, we want to get rid of or cabin Chevron because it's deference to out-of-control agencies that are rewriting the laws and all of this sort of thing. Well, Chevron originated because the Reagan administration was frustrated that out-of-control courts were preventing the Reagan's foot soldiers from deregulating and all the rest. And so, when you get that history and that understanding of it just depends on whether you like what the agency is doing in the first place, that will depend on whether you like the court deferring to it or not, then it seems odd when Neil Gorsuch at his confirmation hearing, you see him assailed by Dianne Feinstein and Dick Durbin, pushing back on his pushback on Chevron and on judicial deference to agencies. So clearly, the Democratic senators want Rick Perry and Betsy DeVos and Scott Pruitt and the like to have more power, because that's the implication of judicial deference to agencies. And you can set up these sort of weird dynamics regardless of who's in power. The major questions doctrine, this is what I like about the paper that Adam has put together. The major questions doctrine might avoid that sort of thing. If what we really care about from first principles is that Congress actually be the one that's legislating, well, this is a way to put not just the agency's feet to the constitutional fire, but to put Congress's feet to the constitutional fire, saying this is a way to prevent Congress from getting away from with passing the Goodness, Truth, and Beauty Act of 2019, taking credit for that, and then when the faceless bureaucrats pass some regulation that hurts their constituents, the congressman could say, well, no, I would never have done that. That's that evil bureaucracy that's doing that. I'm in favor of truth and goodness and beauty, and that's clearly a malinterpretation of what we were trying to do. The major questions is really a cleaner way of getting at the proper balance of powers or the separation of powers than even whatever rebalancing of Chevron or what have you. And that's really attractive to me, especially when the vehicle that's supposed to be doing that, the non-delegation principle, as Cass Sunstein wrote, it turns out this was right before I started law school and had my very first class of law school with Cass Sunstein. He wrote that the non-delegation doctrine has had one good year, 1935, and 211 bad ones at the time. Now we're up to 230 bad ones, I guess. We'll see what happens with the Gundy case. But if the Gundy case doesn't resurrect the non-delegation doctrine, or if it becomes a minor insurrection or minor rebellion like Lopez and Morrison were sort of a minor rebellion against overarching Commerce Clause abuse rather than a Federalist revolution. Well, there's now this major questions doctrine way of getting at effectively the same thing. And I like the, not hiding elephants in mouse holes sort of analogy, nothing to do with today's news about Bob Kraft, but the idea that we don't, at the very least, we don't want to delegate these very major questions. However, that line is policed, and often the rebuke is, or the retort is, there's no way. What is a major question? Are you going to say, well, a rule that costs $200 million indexed to inflation or something? Well, sure, that's a fine line. I'll leave it to the experts, the actual administrative lawyers, not constitutional lawyers, to set that kind of boundary. There are, lines that are drawn all the time in these kinds of prudential doctrines, and so. I'm not an academic, so I don't know how much of the literature covers this. Neither is Adam, for that matter, and that might have some, why this feels like a breath of fresh air, at least to me, because while judges, notably Brett Kavanaugh, notably the Brown and Williamson, these other cases that come up, the doctrine itself is not new, using it as a way not simply to adjudicate cases or as a new canon of statutory interpretation, but actually to rebalance the powers and have, newsflash, someone from Cato wants Congress to have more power, not in general, but, rebalancing how it is in the federal government altogether. I think that is all to the good. And conceiving it as step zero, where we don't even have to get into the debates about what the proper scope of Chevron, let alone our, should be, I think that's very refreshing. And as far as Kavanaugh is concerned, I think that goes concomitantly with his approach that judges need to work harder not to find, let alone manufacture ambiguity in the statutes that they're interpreting. Again, that's a step zero sort of thing before, well, it's sort of step one, but it's also sort of step zero because it's, before you even talk about Gorsuch's other side of the coin about we shouldn't defer quite as much or the scope of deference should be, of Chevron should be less, we should, the question should be presented in many fewer statutes. So I think that's really all I have to say. I think it's in the current anxieties about congressional overdelegation that is presented in the National Emergencies Act. I mean, all of a sudden, nobody had heard of the National Emergencies Act until a couple of months ago, and now half of Twitter are apparently experts. I didn't realize that. But it comes up all the time in lower profile areas as well. And if we can resurrect non-delegation through the major questions doctrine, through a proper and robust application of the major questions doctrine, where hopefully that line that you have to police is fairly low, I think that would be a good way to rebalance the powers without necessarily having to say I'm for or against the administrative state. I'm just going to say I'm for Congress writing clear rules, especially on big things.
So I'd just like to give Adam a chance to respond, and then we will open it up to the panelists to kind of have more of a back and forth.
Thanks, Ilya. So just two responses. One is I don't have a really good answer to your inquiry about sort of the first principles here, although I can't point you to a line in the Constitution that justifies the major questions doctrine. I think this is a structural constitutional value that's being served here, the value of the separation of powers, and legislative power is vested in Congress. The major questions doctrine forces Congress to do its job and be the legislator. We don't see a clear statement of the major questions doctrine from the founding generation, but Chief Justice Marshall in 1925 did say there's a difference between, quote, those important subjects which must be entirely regulated by the legislature itself and those of less interest in which a general provision may be made and power given to those who are to act under such general provision to fill out the details. So there's at least Chief Justice Marshall acknowledging there are some major questions that only Congress can touch. I think you're exactly right that if Gundy doesn't spark a renaissance in non-delegation doctrine, that these sorts of non-delegation canons could continue to play an important role. I don't think they serve exactly the same function because I think, as we've been given it, the non-delegation doctrine is about looking for intelligible principles from Congress. But Congress can be clear, Congress could give intelligible principles or not.
And still be over-delegating.
And still be over-delegating. So just to quote Justice Thomas in his concurrence in Whitman, there are cases in which the principle is intelligible, and yet the significance of the delegated decision is simply too great for the decision to be called anything other than legislative. And I agree with that. I think there are cases where even applying the non-delegation doctrine vigorously would not limit the agency action, but a major questions doctrine could do so where Congress hasn't spoken specifically to the agency's power within a new realm. But I do think they're motivated by the same underlying concerns about overdelegation.
Guys, you make me look like the practical one. You are, honorary academics. I pronounce you that. I spent 5 years on the Hill. I'm about, I would guess, 10 years younger than Boyd and Gray, so not maybe so far from the good old days that he imagined. And I'm here to tell you that we turned the statute I was working on from 50 pages to 200 pages. Congress just doesn't write the good housekeeping, happy life, let's all go home and have a martini kind of laws anymore. They just don't do it. And one of the reasons...
Cato's not allowed to endorse legislation, but in my personal capacity, I endorse that legislation, especially the martini
I'm
pint.
sure you do, because you were hoping for bourbon when the whole thing was over.
That
and
is the
Adam-
whole major question, as I tweeted
And
when the panel
Adam
began.
told you that he was going to have to disappoint you, but they don't do it because the Hill is overrun by lobbyists. During the climate change debate, there were 4 working lobbyists. I'm not saying who they're working for every congressional office, because we never got that breakdown. So the Hill is not left alone to close itself in a dark room and write these vague little love letters to the agencies. Dodd-Frank hated, Obamacare hated. Were both mammoth pieces of legislation. And so the idea that the problem is that they don't write in very specific terms is just wrong. And it would be a fantasy to think that judges would ever get to the point where they overturned every law that they found a little bit vague, no matter what their significance, how long they had been in effect. I mean, you said that Obamacare would chunk the economy. Justice Roberts, for a whole variety of reasons, didn't let that happen, and the economy doesn't seem to be chunked. So there are reasons why judges make these decisions that are not because they're letting Congress get by with these vague, open-ended statements. It's just not what happens anymore. And the regulations are not written by agencies in a dark room all by themselves. In fact, the empirical studies that have been done say that the groups that have by far the most significant input into how regulations are written are regulated industries. And once they've made the investment, they like to leave the regulation the way it is because they want certainty. And that's very important to their business, which is why you had electric utilities at the White House last week saying, please don't repeal the mercury regulation just because one coal company told you to do it. So this is complicated in practical terms.
Well, I think you probably know a whole lot more about legislative practice than I do, and I am not an expert on how things are going right now on the Hill. I think, though, focusing on what Congress is doing today might be a misfocus, because the major questions doctrine is primarily focused on what agencies today are doing with statutes that Congress passed 30 years ago. So for Brown and Williamson, it's the FDCA, I think 58 years had passed between the time that Congress passed the statute and the time that FDA found in it a new authority to regulate tobacco. In the case of the Clean Air Act, I think that provision was probably 1972, that, unless it was 1990, I don't know. But in any event, this wasn't an agency interpreting a provision that had just been passed, but rather interpreting a provision that Congress had passed long ago, and it was now repurposing, because of the ambiguity in the statute, it was repurposing for a new solution. And for net neutrality, the Communications Act, I think, was 1935, and that's what the FCC was using to regulate broadband internet as a commercial carrier. So I will be very pleased if you're correct that Congress is now legislating with greater specificity. I don't know that to be true, and I don't think length is necessarily the same as an absence of ambiguity. But my concern is not so much about new legislation, but about how agencies who are motivated by policy preferences of their own will use older statutes.
But Adam, if you're being honest, if you want to use Brown-Williamson, which was 5-4, then you also have to accept Massachusetts versus EPA, which was 5-4.
Massachusetts versus EPA is a problem for the major questions doctrine because, as people have observed, it seemed to just totally ignore it.
Well, that may
Isn't
be
that a
true, but
standing
it's-
case?
No, the standing case was the minority. The majority said that EPA had the authority to, in theory, to do something about climate change, but first it had to decide whether climate change was endangering the planet and the people on it. And EPA did make that finding, and now we've seen that we're rolling back those regulations. Elections have consequences. I accept that, even though I apologize to my kids about 3 times a day. And I'm just saying that if 5-4 is okay in one case, it's also okay in another, right?
Well, I would agree
Unless
with you
you don't
that
like it.
Massachusetts versus EPA is binding precedent.
Okay.
But I would say that.
And
it
it's
is-
entitled to all the deference that, what's the line that the nominees use,
That's right, that's right. I do think it is inconsistent.
It's not your job to grade your
Destroy these
bosses.
tapes.
I do think Mass v. EPA is inconsistent with the standard version of the major questions doctrine. In that case, the majority, as Rena's suggesting, does seem to cite the importance of the political question as a reason to regulate rather than a reason to demand a clear statement from Congress. So commentators said after Mass v. EPA, well, it looks like the major questions doctrine is dead. And for several years, that's what legal scholars thought. But then the Supreme Court resurrected it in the Utility Air Regulatory Group
And
case.
in Burwell.
And in Burwell.
It sounds like, Rena, that you're agreeing with Justice Kavanaugh that the fewer statutes than we thought are ambiguous, that the Congress is indeed writing tighter statutes, and therefore, we're just engaging in statutory interpretation, not deference, right?
I don't agree with Justice Kavanaugh about much of anything. But we can take statements out
I
of
thought his
context.
pick and roll that he designed for the championship game was quite effective.
He probably likes martinis.
All right. So I have a question which is kind of related to this, which you probably disagree, but I'd like to. Isn't sort of your ideal interpretation? Yourself, Adam. Sorry, of the major questions doctrine is the major questions doctrine just operating as a kind of absurdity canon?
No, I don't think so. I think it does. I can see why you might think they're related. And, in some, take Brown and Williamson, for example, maybe there's sort of an undertone of absurdity there, that Congress couldn't have anticipated that the FDCA would be used to regulate tobacco when it, in subsequent years, did other tobacco legislation that is inconsistent with that. There's something to that, but I think it serves a different purpose. I think it is rightly understood as a non-delegation canon, and therefore, even if the result is reasonable from a judicial perspective, from a public policy perspective, even if you think it would be good and fair for Title VII to be extended to protect against transgender discrimination, that even in such a case, we should let Congress be the one to do that. So I don't think it's an absurdity
So
canon.
just to marry non-delegation with absurdity, though, when I read King versus Burwell, what I was thinking was something like, my gosh, Congress couldn't have delegated to the IRS in this context. The IRS just doesn't, maybe it doesn't have enough economists on staff. Maybe they're highly politicized. Maybe the EPA is better, it's more highly scrutinized, it's a larger agency, better staffed, has a whole slew of economists on staff. Maybe this agency over here, it's larger delegations are more appropriate or more, understandable, and maybe over here for this other agency, or maybe it's absurd to think that this kind of delegation for maybe criminal type issues would be given to the EPA or something like that. So I guess one, can this be relativized to agency by agency? And two, I mean, the second point is I kind of see the two as kind of going together. Certain agencies, looking at King versus Burwell, maybe we're just saying Congress would never delegate to this, it's a highly politicized agency. Everyone hates it on this side and loves it on this side. So, that's, an
And that's
elephant.
what Justice Roberts said.
That is what he said.
That's
There's a-
exactly what he said. He said, I don't want to leave it to the IRS because it's too important, but Adam doesn't
There is-
endorse that.
That's right. There is a line in Chief Justice Roberts' majority opinion in King v. Burwell that it sort of comes at the end of the analysis, and I think is not necessary to the analysis, but he does say, especially this agency, we don't anticipate Congress would have delegated a question like this, a big policy question, to the IRS. I guess I don't really like that very much, because I do think it invites some difficult line drawing problems and gives the kind of discretion that I think the major questions doctrine should be trying to avoid to judges. So I think it's better to have one major questions doctrine that applies without regard to what agency is claiming interpretive power. There may be other reasons for denying Chevron deference to an agency. Maybe it doesn't have jurisdiction over the statute or whatever. But I would keep that separate from the major questions doctrine analysis.
A thought occurred to me, and I'm not sure whether this is the same question that Andrew just asked but rephrased, but what about whether in the propriety of delegation or in terms of scope of deference, you look at whether it goes to the agency's expertise, meaning you defer or can delegate to the agency, to the EPA on matters of, scientific measurements of air quality or what have you, but you don't care what they have to say in terms of the interpretation of the statute. And so, whether an exchange established by the state can include federal exchanges or not, that's a purely legal question. That's not something that a tax expert would have particular knowledge about, and that's why you wouldn't defer to the agency on that question, whether that's a question that has 2 cents of consequence or $200 million of consequence.
Yeah, I think that question of expertise could be highly relevant, especially if we hypothesize a post-Chevron world in which we're back in the realm of Skidmore deference. I think whether a particular agency is well-suited and has the expertise to answer a particular question could be relevant to that decision about whether deference is due to the agency. But again, I think that would be a step 2 question, separate from the step 0 question of the major questions doctrine. In other words, I don't think the court should decide whether the question is major or not based on how expert it thinks the agency
What
is.
if we were just to mix up the steps? I mean, you always start with step zero. Is it ambiguous? Or, if it's not, then, then that's one thing. But
That's step one.
that's step one. What's step zero then?
We don't even go there.
Okay.
We just let the judge decide if it's important.
Well, anyway, what I'm saying is, if you look at expertise before you look at, is it a proper thing, then, as I said, you would look at, is this a delegation of a scientific question versus a purely legal one, regardless, again, of how ambiguous the statute is or how important the rule is.
Somebody wrote a paper it's called "There's Only One Step," and so I think you might be onto something. There is a sense in which these all kind of jumble together, and when you read Brown and Williamson and UARG, they sort of are loose with their language about ambiguity and reasonableness, and I think this is there's a temptation to mix them all. I think there's virtue in clarity and in being precise about what it is exactly you're doing. And so my instinct, which might be wrong, but my instinct is to separate this threshold question of majorness to decide first, is this a question that is really appropriate for delegation to an agency, or is this the sort of major question that Chief Justice Marshall was writing about that is only appropriate for the legislature without regard to expertise?
It's not third base.
Right, so even if it's
Not
clearly,
perfect.
even if it's
Just-
clearly in the agency's wheelhouse, it's too big a question that should be decided by Congress regardless.
If I could maybe zoom back for my question just a little bit, and maybe not go to the granular level of like expertise over a certain tax policy, but is there a difference in your mind between independent agencies and agencies that are specifically under the executive? I mean, does the size of the majorness matter with proximity to the legislative branch?
Well, if the major questions doctrine is motivated by a separation of powers concern, as I think it is, then interpretations by independent agencies are perhaps even more problematic than executive branch agencies because they're that much farther removed from democratic accountability. So that may be a reason to be particularly wary of delegating major questions to independent agencies, but I think the analysis ought to be the same. But I think that's a good point, that we should be especially concerned about the risks of overdelegation to independent agencies.
All right, I guess we can open up to audience questions. We do have mics that are roving.
Only major questions, please.
We'll answer, we'll determine whether it's a major question as you're asking it. Oh. So, right here in the front, please. Thanks.
I guess this question would be appropriate to any of the panels we've had today, but it occurred to me with your panel. Major questions, intelligible principle. Does anybody think that Chief Justice Taft, in writing J.W. Hampton, thought that by penning that phrase, intelligible principle, he was giving an ordering principle to the non-delegation doctrine for decades to come? It doesn't strike me that way. It strikes me as a sort of a stroke of the pen that took on an importance that its author may not have had in mind for it, but just like to get reactions.
Well, I wouldn't disagree with that. I'm no expert, but I think a lot of these major overarching administrative law doctrines, Chevron, I think, included, probably didn't originate with the thought that they would be setting standards for all the cases that would follow. But I would be interested to hear anybody else.
I think you're right.
I'll defer to that evaluation.
So when Justice Scalia argued in favor of Chevron deference in his '89 Duke Law Journal article, he said, these presumptions that are built into Chevron, they make sense at this moment in time, presuming Congress delegates this authority to agencies. It makes more sense now than it might have 50 years ago. And earlier in the conversation, whether it was Andrew or Adam, one of you said, so much of what we're talking about is second-order principles, right? This is a matter of first principles, but second-order principles. And I'm just curious for the three of you, as you think through these issues of major questions doctrine, non-delegation, and Chevron, are these areas where the courts should look for a standard that fits once and for all? We say intelligible principle, and that's the standard forever. Or is this an area of law where it's open to debate and be recalibrated in light of sort of the way the rest of government has shifted around it? Like, for example, my sort of pet theory is that one of the reasons why Congress is gridlocked is because agencies have been delegated so much power by past Congresses that it relieves all the hydraulic forces that might push the new Congress to legislate. Everybody knows the agencies will go do what they want to do. If that's the case, that would argue in favor of a more rigorous non-delegation doctrine right now to kind of push Congress out of its cul-de-sac, but not necessarily forever. Just curious if you have any thoughts on how courts should think about the standard setting here.
Well, I think as a descriptive matter, that's certainly right, that we see the major questions doctrine and similar non-delegation doctrines emerge in response to over-delegation, in response to the failure of the non-delegation doctrine to really police the boundaries. And so I think as a descriptive matter, that's right. I'm a little wary of suggesting that, and therefore we ought to recalibrate these doctrines based on how we view the politics of the moment. To me, that smacks of the kind of judicial discretion that I think this doctrine in particular should be avoiding. So maybe the way I would say it is the major questions doctrine would become less important and less useful in a world in which Congress is doing the things that Rena says Congress is doing, and therefore agencies don't have to be creative, they just follow the instructions they've been given. So in that kind of world, and maybe we will get to that world because the new statutes are more prescriptive, in that world we wouldn't need a major questions doctrine. So I would say yes to the descriptive point.
If we want Congress to do its work, we need to publicize that it only works 2 days a week. It does not follow the regular order. It spends far more time dialing for dollars than it does writing laws. It has, in a stunning reversal of normal procedure, gotten rid of timed votes. It extends votes to be 2 hours long when 3 hours long, leaving plenty of time for powerful chairmen to walk around the floor and drape their arms around recalcitrant members. You can hear the bones crunching practically. And we need to get rid of Citizens United. That's the solution if you want them to get back to work. They, at this point, they are surely the broken branch, although there is a more up-to-date version of that book. It's called It's Even Worse Than It Looks. I commend it. It's by Thomas Mann and Norm Ornstein, and it's a fabulous book. You want to understand what the institutional problems are with Congress. And, nobody lives in town. They all go home on Thursday morning. Families have no contact with each other. It was different when Boyd and Gray and I were up on the Hill. Not that we were there simultaneously, I have to mention.
I agree with the diagnosis, but not with the prescription. In fact, committee chairmen are weaker than they were before. It's all run out of the Speaker's office and the Majority Leader's office and whatnot. The reason they're dialing for dollars isn't because of Citizens United, but because Buckley distinguished expenditures and contributions, which is why we need to get rid of contribution limits, and so they could just focus on legislating. Although having congressmen distracted from legislating and doing something that might be a feature rather than a bug. Who knows?
So
Who
you
knows
gotta
what?
pay
Who knows
your
what
money.
problems we're avoiding through that?
You got to pay your money and
Yeah.
take your choice.
But no, I mean clearly, they should work more than all these other things.
As moderator, I'll rein this in just a little bit to go back to the focus of the paper, but I do have to say that this is relevant, and it has been relevant on every panel today, and it has been people from, every side of every political aisle imaginable that has come back to the same theme. And it was not intentional. I think it's sort of implicit in the subject of the conference, which is delegation, non-delegation, and un-delegation. But really, just every single panel, no matter the topic, we've come back to the fact that there is an issue with Congress. There is a major problem with Congress, and that it may deal with money, may deal with leadership, but with people just having huge incentives to pass the buck. So anyways, do you have anything else you want to add?
I would agree wholeheartedly, and I would just add that one of those incentives is the background knowledge that the agencies are out there to sort of do the hard work of policymaking if we don't do it. And I think the major questions doctrine would shift, a robust application of the major questions doctrine helps to shift those incentives and would be one factor.
Has
although
Mike
there
Lee
are
seen your
others.
paper, Adam? Has Mike Lee seen your paper? I'd be curious what he has, because he's running that whole Article 1 initiative and kind of those same themes. But
That's a good
I'd be
thought.
curious, and I'd be curious to,
We'll make sure to forward it. So we'll go around for questions again. Right over here.
Hi, this is a little bit off the subject of the paper, but since we've already gone to Citizens United, I guess that's okay. Major questions made me think about major rules, which made me think of the Congressional Review Act. It seems like that is directed towards a similar goal of re-empowering Congress to make the big decisions. So what do you guys think about that? Does it have any value? Could it be revitalized, or is it just paper shuffling?
Well, I think you're right that those are motivated by different, but by similar impulses. And that's why in my paper I mentioned that when then Judge Kavanaugh talks about the major questions doctrine, he renames it the major rules doctrine. And I think what he's trying to do is probably exactly what you've suggested, to show this is really about the same thing. It's about making Congress be in charge of and take responsibility for major rules or significant regulatory actions in the language of 12866. So I think there's something to that.
Do you think, just a quick follow-up, I had a kind of odd, do you think that Congress could pass a law defining what you mean by a major question with some of these objective factors that you were listing? In other words, I mean, the same question is, could Congress pass a clear statement rule kind of a thing, but, yeah.
Yeah, that's an interesting question. I'd have to give that more thought. I mean, Congress can pass a dictionary act that says how its statutes should be interpreted, and this is a canon of interpretation. So I think it's an interesting idea. I always get a little nervous when I think about Congress telling judges how to judge. But I think as long as it could be cabined to how acts of Congress ought to be interpreted, I think that could be legitimate. But I have to admit I haven't thought about that.
About the Congressional Review Act, because Adam wants me to represent my end of things. I feel confident. The Congressional Review Act, the major advantage of it is that it waives the filibuster rule in the Senate. Therefore, 51 votes goes. It also limits the time of debate to 2 hours for each side. There was an absolute feeding frenzy on K Street when people realized that there were numbers of rules, and I am critical of the Obama administration for sending them all up, but he sent them up in the last 6 months. It seems a little bit outrageous that a president should lose 6 months of his second term when he was elected by the people. Anyway, there was a feeding frenzy on K Street. They all ran up there. The ones that were most powerful, oil and gas, the NRA, got somehow to the head of the line. I would have loved to chart that one. And when each rule came up for a vote, the Republicans waived their 2 hours. They weren't even willing to stand up and have a conversation about the rule for 2 hours. So I don't think the Congressional Review Act is Congress in its most glorious moment. I would just.
I agree. The repeal authority should be extended beyond 6 months.
Yeah.
So
There were only 13
You would like the
or so.
Reins Act.
The Reins Act, exactly.
There were only 13 or so repeals, so I'm not sure that in
weren't
its
that many,
current
yeah.
form, the CRA is a.
15.
15, okay. I'm not sure it's a very powerful tool for reining in the regulatory state, but.
Although Todd Gaziano has an interesting argument that since the relevant agencies didn't submit the paperwork regarding to their regulations, then you can,
yeah, the clock hasn't started. So these are very interesting questions, a lot of it related to internal Senate procedure. We will have a May 2nd conference at Capitol Hill, a lot of the agenda to be set that may address a lot of these questions. So I hope you continue to follow the center's events. We'll have time for one more question right over there.
And I don't know if this is really totally on point, but one area that I have followed and frustrates me is the issue about security clearances, and there have been, I don't know how many congressional hearings about that, and it's a horrible crisis. But as far as I know, that process is covered by executive order, and Congress, I honestly don't think they've done anything. I don't know, besides have the hearings and scream and yell about how horrible everything is, so.
I don't know much about that. I would suspect that that's probably not a major question, even if there's an agency involved. It could be important to the individual, important to the news cycle, but probably not the sort
No,
of.
it's not for an individual. The whole process isn't working. There's a huge backlog, and like Senator Warner said, I'm not talking about one individual person. I'm talking about the whole process is dysfunctional. And
I think the White House had overrides of people who were going to be denied clearances as well.
I don't know enough about that.
I know nothing.
All right. Well, thank you all for coming. With that, we're going to close. Thank you, Adam, and thank you all of our other authors. Papers are online.